Honorable Court is now in session. Please be seated.
Thank you, ladies and gentlemen. We are ready to proceed with our second case here this morning. Mr. Clerk, would you please call the case?
State of Tennessee versus William Tony Burrell.
Good morning, Justices.
Good morning.
For the privilege to be here today, I would ask to reserve 7 minutes for rebuttal.
Thank you.
Judge, Austin Hayes from the McMinn County Bar. Just a brief rundown of the facts before we get into the issues on this case. Back in 2018, in the little town of Benton in Polk County, Tennessee, an anonymous call was made to the 911 dispatch about a truck with a license plate said to have been speeding. An unknown amount of time later, an officer saw what he believed to be the same truck passing him in the opposite direction. The officer did a U-turn, testified at the motion to suppress hearing that after the U-turn there was traffic in between him and the vehicle, and during the time from when he personally observed the defendant to the time that he parked behind the defendant, he never saw any illegal driving, any speeding, any kind of traffic violations. At that point, the arrest was made subsequent to that seizure. We had a suppression hearing at the criminal court level. The criminal court judge ruled that there was a seizure, but the facts in that case were enough to say it was a reasonable seizure. So the parties worked together, myself, my former boss, Mr. Matthew Rogers, the state's attorney, Mr. Matthew Stowe, and the trial court to craft an order that would hopefully suffice to this quagmire of Rule 37. In that order, the facts, the suppression issues, the rulings and determinations were all presented, along with the question itself in the order. At that point, the trial court signed off on it, along with both parties. We went to the Court of Criminal Appeals, and at that point, the Court of Criminal Appeals said it's too void and it's vague. So here we are today to argue about whether or not the law should be changed on it. I think we're lucky enough, myself in this case, to have heard an argument on very similar issues, just the case right before this one. And your justices, your honors, asked some very great questions that I was going to talk about.
Why, thank you.
So I would like to start off by talking about the fairness issue, the quasi-contract issue. If the state is a party and the defense is a party, and we have a meeting of the minds to say, hey, we will take your plea deal if you agree that this should go to the Court of Appeals to have a hearing on the merits. At that point, they are waiving any objection to jurisdiction. The state is agreeing, yes, they have jurisdiction. We are stipulating to that. But then along the way, common sense just left the room.
Well, if we were to take, I guess, that approach to prevent the state from changing its position,
Yes, Your Honor.
that if this issue is jurisdictional, that still wouldn't mean that we would have to decide the case. If there's an issue that's truly not dispositive or where the question's scope and limits aren't carefully defined, then we would still have an independent obligation, if it is jurisdictional, to determine that those requirements are met. Isn't that right?
That is correct. Under current law, that is correct.
So locking the state into a particular position doesn't necessarily solve the problem.
Doesn't necessarily solve the problem, but it does. The problem is the state wants to have their cake and eat it too. They want to be able to agree to this deal to have a plea deal so that they don't have to spend money on a trial. And that's the whole point of this whole rule, is so that we don't have a room full of this many people missing work in a small county like Polk County, where the economy is essentially shut down because during a voir dire process, we got to have 100 people. And so all of these people are missing work when everybody in that room, the judge included, agrees, hey, this should just be heard by the Court of Appeals.
So your position, though, is that even under the existing rule and framework, that this question actually satisfied the scope and limits requirement, correct?
That is correct, Your Honor.
Okay, can you explain, I guess, your position on that?
So, Your Honor, based upon recent case law, most recent, this court decided back in 2013, Springer, the question in that case was not very specific. We have a long line of cases. starting back with Harris in 99, going to Cox, going to Daly, going to Springer, going to Bell, going to Hogan, where the decision by the Court of Criminal Appeals to dismiss my case because they said it was vague was totally not the same decision that this court held in those cases or the Court of Appeals held in those cases, insofar as it's just a mess. It's one court says, well, we'll agree to that. You're right. This needs to be heard. And almost the same framing of a question, another Court of Criminal Appeals says, no, that doesn't work. In fact, if you look at the Springer case, at the intermediate level on the case history, that was not a unanimous decision by those justices. One of those justices, or the Court of Appeals judge, on the Springer case said, no, this doesn't certify, this isn't dispositive, this doesn't meet the standard. Two of them felt that it did. So even the Court of Criminal Appeals justices argue about this. It's like a big gray area.
So I would completely agree with you that this area of the law is a bit of a mess, that there's a lot of conflicting case law about what is required to satisfy the requirement. So we do, I think, have the authority within our existing framework and under the language of the rule to clarify what scope and limits means. How would you propose that we add some clarification to this area of the law?
One recommendation is, if you look at the State v. Daly case, if you look at the certified question presented in the State v. Daly case, it was like 2 paragraphs long. It included facts, it included testimony, it included law, it included all kinds of things. At that point, it's not a question anymore, it's just a statement of the case. So we could change the language to say, hey, what's the certified statement of the case? And that way it's in there. That way the Court of Appeals doesn't say, well, you didn't meet this little thing, or these hyper-technical issues aren't a problem. Or another option would be to say, when the state, when the defense, and when the trial judge all agree this issue is dispositive, this issue, to the point of, the rule itself requires the judge and the defense and the state to agree that this question is sufficient at the trial level. If all 3 of the parties that are involved in the case agreed to that, how can it not be enough?
Well, what should, so for example, what if the question, so this question does include some of the relevant facts, right, that would bear on the analysis, the seizure analysis here. But, suppose the question just said, whether or not an unreasonable seizure occurred when the arresting officer blocked his vehicle into the parking spot and omitted all the other facts. In your view, would that be enough to satisfy the scope and limits requirement?
Comparing it to previous case law, like in Springer, like in those other
Well,
cases,
let's set aside previous case law, but just, in your experience as a defense attorney, what is enough, to allow a reviewing court to answer the question and to sort of define it in a way that, I guess, is fair to both parties to the guilty plea, right? That, so that the court doesn't end up addressing a totally different question than the parties actually agreed to have addressed.
And Judge, or Your Honor, I'm sorry. Your Honor, I believe that part of case law with Daly says, look at the record. Look at the record to see what's dispositive and what's not. So that law is saying, look outside this specific question. To your question, if we remove the specific language, the fact-specific language, I believe it still would, because on a DUI case, to prosecute on a DUI, if the stop is ruled bad, there's nowhere to go. There is no other proof. It all stems from that officer's interaction. And in this case specifically, it was about a past speeding allegation. That wouldn't factor into DUI at all.
So your position is, if the question had just said whether an unreasonable seizure occurred, then, that in connection with the record that the court is obviously sort of limited to when it's reviewing this case, that's enough. But I suppose it wouldn't have been enough then if the question had said, was the Fourth Amendment violated in this case?
I don't like that approach. We have that approach in some of the case law that I have cited to. I think that is vague. I do think there should be some limits on it. There should be some scope. If you will, it's supposed to give the Court of Appeals a box to work in. And so the Fourth Amendment or the Tennessee Constitution is really just what governs all the law in Tennessee. So that's not really a narrow box. But when I say, was the seizure unreasonable based on these specific facts, it's not a whole huge practice area, it's a box. Did the Fourth Amendment get violated with these facts? And I understand at the Court of Appeals level, they said, I did not include language such as the Fourth Amendment. It could have been artfully drafted a little bit better. I'll be the first to admit, it could have included better law school language. But we all knew what it was talking about, the unreasonable seizure. In fact, one of the judges on the court panel, we talked about that during our hearing, during our oral arguments at that level. He said, it's pretty clear what we're talking about. In fact, we spent the whole 20 minutes of each side talking about the facts of the case, not so much the dispositive nature of it.
So would you have us adopt a substantial compliance test, or do you agree that as the law stands today, that Rule 37, there must be strict compliance with Rule 37, and should that be changed? You started your argument by saying that we're asking you to change the law, so I'm a little bit curious about that.
Judge, I believe it would depend on are we happy with how much it's being used now? I would say no, we're not. This is, like I said, it's to avoid unnecessary jury trials. So I think we want to open the door up a little bit more to use this as practitioners. So to change it, to open it up, I would almost say it's more like the reasonably calculated, or to reasonably articulate as far as the civil service standard, right? There's not one specific way to do it, but if you can identify and if you can box it in, and we know what you're talking about, like the court in Harris said, that's what we need to know.
Well, a little bit more is relative a bit, right? So what I'm really asking about is, where does strict compliance end and substantial compliance begin?
The court in Daly said strict compliance began by the question itself, then looking at the record. Other courts, subsequent courts, Court of Criminal Appeal Court says, no, your question's got to be so hyper detailed and so including all of these things that we've added to Preston, otherwise it's going to fail. And using the state's argument, pretty much they think that a seizure could never be brought on this case.
So I get your exasperation, but I'm trying to focus in on answering Justice Tarwater's question. I think he's asking for some precision. What exactly are you advocating that we do?
Justice, I would advocate that we use the Harris standard that started back in '99, which, in my opinion of reading of the cases and the subsequent case law that followed Harris, as I outlined in my brief, the question itself has to be more than the Fourth Amendment. It has to be what area is it? Is it the unreasonable seizure and what facts went with it? And then we also look at the record. I don't think we should have to comb the whole record, because we don't get here unless there is a motion to suppress or a motion to remove evidence. So it should include the question itself, the defendant's motion to suppress, the judge's answer to that motion to suppress.
Are you, in effect, asking us to use a substantial compliance standard?
Judge, I think at this point I'm asking just to change it. Just to change it completely to...
I get that. I'm trying to home in on change to, you can't just shrug or say we
change
all
it to
know,
what? Yeah.
And that sort of thing. We have to use actual words in an opinion or in a rule. So what actual words are you asking for?
I would ask for a new standard that allows the court, when determining the scope and limits, to also include not only the question, but also maybe the statement of the case, or maybe the motion to suppress along with the judge's order on that, along with the agreed order like my case had, that lays out why we're here and why this is what we're doing and here's why. So language that would include even just those 4 documents.
Okay.
How would you define the scope and limits requirement?
The scope and limits requirement, are you asking how I would define it under current case law or how I wish to define it?
Well, I figure you're here today to try to
I understand it.
try to get a little relief, like shoot, but you can't just say shoot up here amongst us, right? So what are you advocating for today on scope and limits?
If you're going to reference Jerry Clowery, you need to say Jerry.
I thought you told me that, Justice Kirby.
How would I define scope and limits? I would define them as, and Justice, quite frankly, I think it depends on what the nature of the motion to suppress was. Is it a motion to suppress, or was it a motion for improper, like the state said in the last case, wrong venue or wrong whatever, as far as place? I would ask, as far as for motions to suppress for invalid seizures, I would say the question, the scope and limits has to do with what happened with that seizure. That particular seizure in that specific case. The facts that led up to that seizure, and was it warranted? Was it reasonable? If it wasn't reasonable, then it should be tossed, especially in DUI cases.
What do you see as the role or purpose of the question that's being asked? Why do we make you have a question?
I think it's to box in a limited area, because that is in my opinion, the difference in an interlocutory appeal. And this one, we're scoping it in and saying this is dispositive. The judge agrees with this, that it is dispositive. The state agrees that it's dispositive, and defense agrees it's dispositive. So the purpose of this is, if you answer this question in the affirmative that it was an unreasonable seizure, the case will go away. If you don't, then the plea stands. So it's almost like an interlocutory appeal, but with finality.
Well, that's related to my next question. Is it or should it be similar to an issue statement or question in a Rule 3 appeal?
I would say yes.
Yes, it should, or yes, it is.
Can you ask one more time, Judge?
I'm sorry, I asked a compound question. I apologize. Is it currently or should it be similar to a statement of issues or a question in a Rule 3 appeal?
I think that it should be similar to the statement of the issue, statement of the question. Because when we do that on just any kind of regular appeal or after a motion for new trial or anything like that, we still have to tell the court what we're talking about. We can't just open, I guess it's best practice. I would not want to say, was his Fourth Amendment violated after a motion for new trial? That's so vague, and that opens the door to Pandora's box. It needs to be specified to an extent, for sure, but to what extent? The state's asking for a hyper-technical approach. The Court of Appeals, through their opinions, are asking for this hyper-technical thing to where it seems like they don't want to have to look at the record at all. I believe it was even mentioned in my opinion on this, or the opinion given in Mr. Burrell's case, the court shouldn't have to look at the record. Well, at that point, it's not like I said earlier, it's not a question anymore. At that point, it turns into a statement of the case. And so we got to ask ourselves, what do we want? How can we effectuate some change so that this avenue can prevent unnecessary jury trials or bench trials? Because nobody wants to sit through an unnecessary trial. It's not fun.
Well, in this particular case, actually, did you represent the defendant at the trial court?
My former boss, Mr. Rogers, did. I was his associate at the time, so we were co-counsel on it. He was the lead.
All right, but you had your client, and he was offered a plea deal, a conditional plea deal,
correct, yes.
right? And you had an agreement with the prosecutor, and the judge approved it, and your client approved it, right?
That's correct.
And so this certified question goes up, and then the Court of Appeals says, no, question's not any good. Appeal dismissed, and that left the guilty plea intact, right?
That's correct.
So, you know, if you heard the previous argument, we were really concerned about the public policy and people being good to their word and that kind of thing.
That's correct.
And so you think your question's okay?
I do, Your Honor. I do. I believe at the root of the question, as it's worded, is was that seizure unreasonable? And it's not even a question of was there a seizure. The trial court ruled on that and determined that there was a seizure, and in the later opinion from the trial court allowing the agreement, confirmed that it was uncorroborated. So as it's written, yes, I believe it does give a narrow box to was this seizure bad? What should, even as a public policy, that's the whole point of the question, I think, is should someone who calls in for speeding be allowed to give an officer authority to pull somebody over or to seize them? In this case, he didn't get a
Well, you
chance.
didn't pull him over.
He didn't get a chance to pull him over.
He pulled himself over, but the law enforcement blocked him in, right?
That's correct, Your Honor.
And he couldn't go out the other way?
That's correct. There was the wall was in between, yes, Your Honor. And in that avenue, most of these certified questions aren't trying to change law entirely. They're usually answering some fact-specific question like this one. We just don't see that a lot. Somebody got seized, according to the trial court, based on that court's ruling, based solely on an anonymous tip of speeding. And so the point of coming to the Court of Appeals was, is that okay? Is this what we're going to allow? But somewhere along the way, we can't just have that answer. Everybody, the state wants to say, you're right, we should have an answer to that question. But then we get to the Court of Appeals and they say, no, you shouldn't. So which is it?
Okay, does the record reflect that the only reason law enforcement was there and pulled up behind him, this tip?
It does, Your Honor.
That's the only reason?
It does.
Okay.
His testimony along with the trial court's order, both orders, I believe, Judge.
We're having some feedback issues, but we've heard you, but say that one again.
In this particular case, Your Honor, not only was the testimony from the officer at the motion to suppress hearing given that was the only reason he stopped. He never saw anything illegal. The trial court further put that in that trial court's order and in the agreed order that there was no finding of any kind of wrongdoing, just a positive identification, maybe, because they didn't bring the 911 caller to the suppression hearing. There was no ID of the driver, just a tag and an unknown amount of time later. And given the suppression hearing, Your Honor, there was no positive ID of the tag until after the seizure occurred because the officer testified he had to turn around and there was cars in between them. And as soon as he pulled off, he parked behind him. So it's just seeing a red truck.
Your client had a few beers though, right? Isn't that what he said?
I believe if you watch the remainder of the video, there was some talk of that, Your Honor. That's not why we're here today.
On that note, thank you, Mr. Hayes. Mr. Cloutier, in our previous argument, you, I believe, said that the appellate courts have not really defined scope to much extent so far. So how do you suggest we define it?
So, Your Honor, I think it's a little hard to define, if I'm being candid, but I do think our approach is akin to sort of a question plus record approach, and it does sort of sound like something that was discussed in the questioning earlier in my friend on the other side's argument. But as we understand the proper understanding of this, I think it should be that the question contains enough information so that the court can read the question in conjunction with the record and know what is being addressed. So in our view, a fairly broad question is perfectly fine. If we can look back to the previous case this morning, I think if the question in that case had said, did the trial court err in denying the motion to suppress, I don't think we should have a problem under a proper interpretation of the scope and limits requirement. That clearly is broad enough to enable the court to address the necessary legal aspects of the inquiry, to properly apply the probable cause test and consider the totality of the circumstances, and it thus enables the court to kind of reach a dispositive, a case-ending conclusion. I think, you know, we take the point of obviously that is fairly broad, but I think the way this could perhaps work in practice, and I recognize this is not kind of a bright line rule, but is sort of a sliding scale. So the simpler the case, the simpler the question can be. If you filed one motion to suppress based on, you know, one seizure or one piece of evidence, a very straightforward question coupled with your straightforward record is going to give the court more than enough to go on. I think the more complex the case, the more kind of specific the question would probably need to be. If you had multiple pretrial motions, for instance, I think for the question to have proper scope and limits, it would have to direct the court to which pretrial motion it was focused on. I think if you had a pretrial motion involving a bunch of different arguments or different pieces of evidence and you only cared about one of them, likewise, I think you'd want to make sure that the court was directed to the proper thing. So I think that's why, you know, I think to Your Honor's points earlier, a question that's simply, you know, was the Fourth Amendment violated, I don't know that that would cut it. But I think one that's targeted to a specific pretrial motion dealing with specific evidence that is contained in the record will suffice. And that's kind of akin to how it works in the federal rule. In the federal rule, it is targeted to particular pretrial rulings, not necessarily, you know, questions of law in the abstract. So I think this would enable us to move somewhat closer to that approach without even requiring an actual change in the rule. And I want to be clear, I think to the extent, and I mentioned this in the argument earlier, we understand there to be a problem in the way that the Court of Criminal Appeals has been applying this rule. We think a lot of that does stem from its application of the scope and limits requirement. Because again, I think the more complex the question, I think as it was brought up in the earlier argument, if you've got a multi-paragraph question involving various aspects of precedent and you know, various facts, the opportunities for error necessarily increase, you know, with the question becoming more elaborate. So the simpler question, I think, does result in a lesser burden for defendants to actually, you know, get their question heard by the court, at least in scope and limits terms. I think we still understand the dispositive requirement to be doing important work for all the reasons we discussed earlier. But all that to say, we don't.
What do you see, being candid, what do you see the intermediate and appellate court doing with scope and limits that is a problem?
So I alluded to this earlier, but I think what I understand them to be doing in some of these cases, and I'll mention one, which is State v. Upton. I believe it's from a couple of years ago. But that case, the court that expressly announced kind of this four corners approach, and it drew on a couple of its own prior cases. I wasn't able to find any basis in this court's case law for that approach, but that's again the case where they specifically said that as they understand the scope and limits requirement, they should not have to look at anything beyond the question. Shouldn't have to look at the record, shouldn't have to look at the trial court's opinion, shouldn't have to look at the briefing. And I think that's really hard to square with this court's decision in Daly, which said that determining whether or not a question is dispositive is a record-dependent inquiry. So we think, again, to the extent that there's, you know, a good opportunity to clarify things here, it's likely in reframing the kind of function of this scope and limits requirement. And if I can just take a step back, I think we really understand the way this should work, as we understand it, is that the scope and limits requirement should rarely be doing the bulk of the work. I think the dispositive requirement is what's really important to ensure that this court is hearing issues that actually matter, not sort of, you know, small-scale disagreements that wouldn't ever actually resolve the case. I think that's how we get to a rule that enables us to facilitate this kind of final resolution and further the efficiency-related goals that I think underlie Rule 37.
What does scope and limits mean? What does that phrase mean to you?
As we take it, I think it just means that the question has to be sort of broad enough to enable the court to address the actual legal question that matters, but, you know, narrow enough so that it can tell what the question is. And I, again, recognize that's not a particularly clear, bright line rule, but that's part of why, you know, we say that perhaps scope and limits shouldn't be doing the bulk of the work in dismissing these cases. But I think if
Should we do away with that requirement?
I think the court certainly could, but that would, of course, I think have to happen through rulemaking since it's now been added to the text of Rule 37. But, you know, we certainly would not resist that because I don't understand it to be doing a particularly meaningful amount of work in most of these cases over and above what is done by the dispositive requirement. But I think if I can point to this case as an example, perhaps, I think part of the problem here for scope and limits purposes, at least as we see it, is that the question is drafted too narrowly for the court to actually address the necessary legal inquiry. So the question here is framed solely around the reasonableness of the seizure of Mr. Burrell's car. And I think as we understand that, that means it prohibits the court from reaching what I think is ultimately the more important question about whether that perhaps unlawful seizure would result in suppression of evidence. That's an entirely separate inquiry that involves consideration of kind of the deterrence value of suppression, as well as the degree of misconduct by an officer, and then I think even beyond that often entails consideration of the degree of attenuation between any Fourth Amendment violation and any actual discovery of evidence. But I think the way this question is framed, all of that is outside the scope of the question and thus can't be considered, at least as this court has understood the certified question process in Day, where it said that you cannot go beyond the scope of the question. So I think that's an example of the certified question being too narrow, and thus I think having insufficiently broad scope and limits. So I think that's sort of the floor on the scope and limits requirement. As far as a ceiling is concerned, I think we understand it again to be perhaps doing a bit less work, but if you had a case where a defendant filed 4 pretrial motions and then just filed a certified question asking, did the trial court err in denying my pretrial motion, that doesn't tell the court what it's looking at. So I think it would have to be more specific than that. But if you have one, again, that's one pretrial motion and the question says, did the court err in denying that motion, that gives the court more than enough to work with and determine whether or not, say the defendant's rights were violated.
So if we adopted the approach that you're advocating here today, and we applied that to the current case in front of us, and specifically I'm thinking of, I think you articulated the fact of being able to look at the question and the record, correct? If you looked at this question and the record, applying that standard in this case, would this, in your opinion, would this question be sufficient?
It would not, Your Honor. And I think, again, that's largely because it's too narrow. So I don't think this is a scenario where the question is too broad for the court to understand what's happening. I think, again, it's too narrow.
So the record couldn't help that?
I don't think so here because, again, I think what this court said in Day is that in the certified question context, the court is cabined to kind of the text of the question. So if the question only asks whether the seizure is reasonable, this court can't kind of conduct the broader, more important inquiry about whether or not that seizure should result in suppression of evidence. And I think this again kind of aligns with.
But doesn't it presuppose that the trial court and the prosecutor and the defense counsel have already agreed on what the answer to that question is?
I think you could perhaps conclude that it presupposes that, but I think, again, that's hard to square with the way that this court has traditionally treated these certified questions. I think if I can give a slightly different example, in Daly, this court was discussing, kind of whether or not these questions were dispositive, and it cited to a long string of cases in which a defendant had moved to suppress multiple pieces of evidence, and then I think their question was drafted in such a way that it only enabled the court to address one. And this court listed all of those as examples of questions that were not dispositive because they didn't permit the court to kind of reach the other evidence necessary to say that, granting suppression in this case would dispose of all the evidence and therefore end the case. And I think the same thing has to be true when it comes to legal arguments. If you have, a defendant who lost on 2 independent legal grounds and only challenges one of them in his certified question, it doesn't permit the court to reach that second independent basis, and that defendant has necessarily lost because his question is not dispositive of the entirety of the case. So I think, again, to return to Chief Justice Bivens' kind of question that prompted this, I think even if this court were to adopt our more kind of flexible, I suppose, approach to the scope and limits requirement, I don't think it solves the kind of too narrow problem that we have with this particular certified question. Nor do I think it gets around the kind of factual premises that are baked into this question, which we did discuss in our brief, but I want to briefly touch on here. In the previous case, we talked a little bit about how I think the question, at least in our view, foreclosed consideration of the totality of the circumstances. So it isolated a single fact at the exclusion of everything else. In this case, we have a similar problem, but I think worse than that, we have a question that bakes in factual premises that are contradicted by the record. So I think here the question presupposes a stop based on an anonymous call, which is true, but then it goes on to say that that call did not identify the vehicle and that none of the information from the call was corroborated. And as we see the record, I think that flatly contradicts the text of the question. Because again, the 911 caller provided the make of the vehicle, which was a Chevy, a color, which was red, and gave the license plate number. And then when the officer arrived on the scene, he found a vehicle that matched on all three points. And I think this court has previously said that when an anonymous tip is given and then an officer is able to corroborate some of those details himself, that enhances the veracity of the tip. So I think, again, what we're faced with here is either the court has to kind of answer the question on its own terms, which here I think would be on non-existent facts or facts that differ from those in the record, or it has to kind of exceed the scope of the question, disregard the facts that are baked into the question, and then consider the record itself. And I think either way, the court is kind of rubbing up against some of its own precedent. On the one hand, I think it would have to be, I think disregarding its requirement that you consider the actual totality of the circumstances and consider the actual record, which is what this court said in Daly. And on the other, I think if the court kind of exceeds the scope of the question and considers the actual record, it's running up against its decision in Day, where it said that it is a kind of cabined inquiry to the text of the question.
But why, I mean, the state, and I recognize that it was the DA's office and not the AG's office that initially agreed to this question, but I mean, both parties, both sides, agreed to the wording of this question. So why isn't it the case that that is tantamount to a factual concession that the state should now be bound by?
I think, Your Honor, the first reason I guess I'd offer is that ultimately Rule 37 permits certified questions of law. I think that's ultimately what the parties are agreeing to here. So it's not entirely clear, I guess, what the state is agreeing to. I have yet to see a decision from this court that suggests that the state's agreement to facts that are baked into the question amounts to a waiver. I think if we were kind of coming at this fresh, setting aside all this court's past precedent, there's perhaps a way to read it that way. But I think if that were the proper rule, I think a lot of these cases would have come out differently.
But I think what Justice Campbell is referring to is the factual premise for the legal issue. I mean, can't that be conceded?
I think there are ways in which it could be conceded, but again, we don't really understand that to be what's happening when the state agrees to certify a question. I think
When the defendant and the state and the trial judge agree to it, that's not agreeing to the factual basis for that?
I guess I took Justice Campbell's question to be asking whether it sort of agrees in such a way that binds the appellate court to consider only those facts. And I don't think that can be right. And I think this case really illustrates why. Because for whatever reason, the parties here agreed to a question that contains facts that are expressly contradicted by the record. I think a rule that enables this court to address a question on those non-existent hypothetical facts is one that's really hard to square, I think, with the role of the judiciary in general. I think courts traditionally limit themselves to resolving real disputes between real parties, not hypothetical questions based on facts that are expressly contradicted by the record in this very case. And I think given what this court said in Daly about looking to the record to determine whether the question is dispositive, it's hard to see why it would ever matter what the parties think the facts are in the question, which I think takes me back to my first point, which is I don't really understand the scope and limits requirement to require inclusion of all these facts. They don't really seem to have any utility if the court has to look at the record anyway.
I'm puzzled, and so let me ask you, do I understand that your argument that the question doesn't jive with the facts is based solely on the word unknown before the word vehicle? Reckless driving regarding an unknown vehicle and driver, and you're saying, well, it didn't say it was a red truck, and therefore the question is insufficient on that basis?
Not exactly, Your Honor. That is one basis, because I do think the question presupposes a tip that's very different from the one that was actually called in. I think if the court were faced with a case in which a 911 caller called in and said a vehicle was speeding and then hung up, I take the point that that's a pretty tough sell for reasonable suspicion purposes, but that's not what we have here. We have a call that did identify the vehicle. But I think the other factual discrepancy is the question's baked-in premise that this was an uncorroborated tip. Again, this court has blessed the practice of officers corroborating the details of an anonymous tip. And they've said that when an officer is able to kind of confirm the details of a tip with their own eyes, that enhances the veracity of the tip for purposes of reasonable suspicion or probable cause, as the case may be. So I think, again, if I can kind of return to what we were talking about earlier, I think this question poses one that differs from reality. It asks this court to resolve what I think is ultimately a much easier case for the defendant, which is a 911 caller who doesn't identify the vehicle and where the officer is able to corroborate none of the details. Of course, that officer probably wouldn't have reasonable suspicion, but that's not what we have here in this record. So I think, again, the court is kind of faced with either answering the question on its own terms and I think answering a hypothetical, or exceeding the scope of the question and I think running into tension with what this court said in Day about its role in the certified question context, being limited to answering the actual question certified by the defendant.
Did the trial court conclude that the officer observed the speeding driving or the reckless driving?
No, Your Honor. So our point isn't that he corroborated every detail of the call, but he did corroborate every detail of the identification of defendant's vehicle. And again, I think this is important because we're not in the probable cause context where the officer needs to, actually think a crime is being committed. We're instead in the reasonable suspicion context, which is all you really need to justify the kind of momentary seizure under these facts. So, I take the point that that's ultimately the merits question, and in our view, that's kind of beside the point for purposes of this case. But I do think, keeping the reasonable suspicion framework in mind for purposes of assessing the degree of corroboration here is helpful.
Well,
And-
is the uncorroborated in the question that was certified referring to the alleged conduct of reckless driving, or the red and truck and license plate number?
It's unclear. The question is framed broadly enough that I would understand uncorroborated to apply to every detail that came from the caller. I think it refers to I have it in front of me, whether an unreasonable seizure occurred when the arresting officer blocked his vehicle into a parking spot based solely on uncorroborated anonymous caller who allegedly reported reckless driving regarding an unknown vehicle and driver. So I think we take uncorroborated to be a characterization of the entirety of the call, and I just don't think the record supports that assertion.
And so, based on the Attorney General's disagreement with the facts that were agreed to by the local prosecutor, then this appeal should be dismissed.
I don't know that that's precisely how we would phrase it, but I think that is the bottom line conclusion. I think it's less about a disagreement with the prosecutor and more about the fact that, this court has said each court has an independent obligation to assess whether the question as drafted by the defendant is dispositive of the case. And I think a question that isn't compatible with the record, which this court has said it also has to look at, necessarily doesn't fit the bill. And, if I can just point to another aspect of this court's certified question precedent that's been repeated over the years, it's that the defendant ultimately does bear the burden in this. And I take the point that ultimately, I think, results in a rule that is harsh and hard to implement. But this court has been very clear that even though the state is involved and even though the trial court is involved, it is the defendant's burden to draft a question that is actually dispositive and to put together a record that enables the court to review that question. And here, I just don't see how that's happened. So I think the necessary conclusion is that this appeal has to be dismissed for lack of jurisdiction.
So at the CCA level in this case, the state's position, and that being the Attorney General in that situation, was based on scope and limits, correct?
I think it was framed generally in those terms, yes, Your Honor.
And it was not framed in the context of dispositive and jurisdictional.
Correct, Your Honor.
So you are making that argument for the first time in this court. And you're basing that, I assume, on the fact that you say it's jurisdictional, so you can make it at any time. Is that where we are?
In part, Your Honor. It's certainly that, but also, traditionally, I think this court has seen itself as free to affirm on, whatever ground is supported by the record. And we think that the lack of a dispositive question here is certainly borne out by the record here.
Well, we've also said on things if it's not a jurisdictional issue, we've been very hesitant to consider other arguments that are made for the first time in this court, are we not?
Absolutely, Your Honor. So I do think we have to rely on the jurisdictional nature of the rule. We're certainly not shying away from that here. But I think, again, even if you sort of set aside the state's change in position, I think everybody seems to be in agreement that the court does have an independent obligation to assess whether the question complies with Rule 37, and that does include the dispositive requirement. And to be clear, we take a lot of the Court of Criminal Appeals criticisms of this question to be reasonable. I think they point to the fact that it doesn't refer to the kind of corroboration of the information in the record. We've just sort of chosen to frame that not in scope and limits terms, but in dispositive terms, because we think that's the better way to think about the kind of rules failings, or the question's failings under Rule 37. But I think ultimately it's failing for similar reasons. We see the kind of narrow nature of the question as a barrier to it being dispositive of the case for the reasons we've already discussed. So if the court doesn't have any further questions about this particular question, I do want to turn to the potential revisions to the certified question procedure, because I think obviously that was an animating concern, presumably in both of these grants today. As we explained in our brief, and I won't belabor the point, but we tend to think this case is probably an improper vehicle to make actual changes to the text of the rules. We think that's something that's more properly done through rulemaking. I want to get that out there just in case, but I think that's been our view, and I think this court's decision in Webb is pretty clear that when these kind of broader policy questions are at issue, something that enables a wider array of input from different stakeholders is the better way to do it. But to be clear, we don't take that to mean that there's no kind of potential for revision or clarification on the table. I think there's still a lot of things this court can do, and we've talked about some of them, but I do kind of want to run down the list I have. So the first that we talked about, I guess, earlier in this argument, and of course in the last, is we think that this court should clarify the meaning of the scope and limits requirement. Obviously, I think a lot of the dismissals we're seeing from the Court of Criminal Appeals have hinged on that requirement, and I think hinged on it in a way that is, I think, harder to justify when you take a stock of what the purpose of this rule is. So we think that there's room for this court to interpret that requirement to reject this kind of four corners approach that the Court of Criminal Appeals has been adhering to, and we think the court should kind of condone or I guess accept this more record plus question approach that we've advanced, where the court has to sort of take the question on its terms and compare it to the record. So in a simple case, you can have a simple question. In a complex case, your question might need some more detail, but in no event does it require inclusion of, every argument that was raised in the trial court or every fact that you think is relevant. So long as that stuff's in the record and you've kind of built that record as the defendant, we think that will suffice for Rule 37 purposes. The second thing we think this court should do is, again, kind of explain how this dispositive requirement applies in suppression cases. Sort of setting aside the broader question about, I guess, how often defendants should be able to invoke this rule in suppression cases, we still think that at least under current law, until perhaps there's been a rulemaking, there's merit in clarifying that a defendant probably should try to build out a record that really confirms the dispositive nature of their suppression motion. So a defendant who moves to suppress, one piece of evidence out of 5, that's per se not dispositive unless there's, say, this kind of daily style conversation that we've talked about a couple times today. And that sort of takes me to the third point, which is that we think that trial courts should be conducting really thorough plea hearings in these cases and trying to get the state on the record about the effect of granting the suppression motion. And I certainly take the point that you were talking about earlier, Justice Kirby, that this is, perhaps that is how we should read Rule 37. I think our point is that might be true, but it isn't how this court has been reading it. So I think until we do a rulemaking to kind of change it, or until this court is faced with a case that facilitates overruling a lot of its past precedent, we think right now the best kind of stopgap measure is to provide kind of clarification and direct trial courts to conduct these daily style, exchanges with the prosecution to really kind of take a belt and suspenders approach and show that this is a dispositive question on the record before the appellate court.
Mr. Cloutier, let me ask you a question about that. So I think what I heard you say is that the trial court should have a hearing. If the prosecution and the defendant are in agreement and the trial judge approves the agreement, what purpose would the hearing serve?
Again, we sort of understand the hearing to be an opportunity for the state to do exactly what it did in the trial court in Daly, which is expressly say on the record what it understands the effect of a grant of suppression in this case to be. So I think where this comes in handy, I think you could take a case where it's only one piece of evidence, and I think it's easier there to assume that by certifying the question, the parties agree that without that one piece, the case is over. But I think if you have a case where you've got 5 pieces of evidence that are kind of potentially in play, and a certified question only challenges one of those, it's harder to say that that's dispositive of the case in its entirety, because of course the state could proceed on the other 4 pieces of evidence. I think an easy example is if you have a defendant charged with unlawful possession of a gun, suppression of the gun might make it harder for the state to prove its case, but if the record also contains, testimony from a co-defendant or, eyewitnesses on the scene, or really anything else, the state can still proceed. So we understand that to be a non-dispositive question. But this is sort of where the daily style exchange comes into play, because if the state says the gun is our most critical piece of evidence and without that we wouldn't bother prosecuting it, then I think you at that point have a record and you have that hearing as part of the record in such a way that it really demonstrates to the appellate court that this is a necessarily dispositive question. And that's exactly what this court decided in Daly, and we think it makes a lot of sense and would be practically beneficial to get that clarification again from this court.
But what is that? I'm trying to figure out what that gets you. If the state stands up and says, we agree that this is dispositive. If you rule X way on the gun, we view the case as not going forward. AG can still take a different position. The appellate court can still take a different position. How does that increase the deference? Are you talking about only where the prosecutor elaborates on why? Because the prosecutor may have reasons that he or she doesn't want to talk about. The prosecutor may know that a witness is in the process of being intimidated and is probably not going to show up, for example. So tell me, explain that a little bit.
Yeah, a point of clarification, Your Honor. I think we're envisioning an exchange between the prosecutor and the trial court where the prosecutor says, not so much, I agree that the question is dispositive, because I agree. I take the point that that's probably somewhat redundant of their existing Rule 37 certification. But I think what happened in Daly was the prosecutor went further and said, without this evidence, we would stop prosecuting this case. And we understand that to be different in a couple of ways. For one thing, I think it's more akin to a commitment to a litigation position that is more traditionally enforced against a party on appeal. And I think the other is that it's far closer, I think, to a kind of factual representation that's more properly susceptible to estoppel than a legal conclusion that a particular question is dispositive. So I think that's what we understand. And I recognize that there may not be a lot of daylight in theory between the prosecutor's certification of the question under Rule 37 and this sort of plea hearing. But again, to use the term I used earlier, we kind of see it as a belt and suspenders approach to really make a record that demonstrates that this is dispositive, and that does kind of, I think, in our view, preclude the state from changing positions, because it's no longer resting solely on the trial court or the trial level litigation, I guess, view of the legality of the question in terms of Rule 37, but instead about what that prosecutor would do without this particular piece of evidence.
So are you saying then that if that type of a hearing took place and the trial court gets the prosecutor on record as making that statement, then the AG's office would not challenge would not offer a challenge on appeal to whether it was dispositive or not?
Certainly not if it's, I guess, non-dispositive for reasons related to the amount of evidence suppressed and whether the state could proceed in that way. I think if the question were still framed in such a way that it asks the court to resolve, a non-existent legal question, I think that's a different problem. So I think this doesn't, again, solve every problem in these cases, but we do.
I have to admit, I'm leery as to whether it solves many problems at all, because it's still not addressing the issue of the Attorney General taking an independent review of that. And I'm not saying that's right or wrong, but not quite seeing how just asking a prosecutor a couple of questions is going to materially affect the decision-making of the Attorney General's office when it comes up here to determine whether it's dispositive or not.
So we do think it would dictate the Attorney General's position in some of these cases. So again, if we imagine a defendant, or a case, I suppose, involving two pieces of evidence, one of them is really important, and the state agrees on the record in the trial court that without that important piece, we will drop the case. I think there you've got a dispositive suppression ruling. So as long as you have a question that is properly drafted, I think you're in the clear. That is a dispositive legal question, and it's properly certified.
It might go to the meaning of dispositive. Dispositive might mean that, as a practical matter, if this motion goes a certain way, the prosecutor is not going to go forward. It may also mean if there's a certain legal interpretation, then the prosecution cannot go forward. It's sort of it might be that whether dispositive includes will not and cannot.
I do think it includes both, so long as the record supports the will not. I think that's what we understand this daily style exchange to be doing, I think then you've created a record, because ultimately this is a record-dependent inquiry. The court isn't supposed to be thinking about what other evidence, the state could theoretically introduce down the road when it assesses whether or not a question is dispositive.
So it might be that the appellate courts and the AG's office has been looking at the question only through the cannot lens. Is this a situation where the prosecution cannot go forward? And what you're proposing is really a more inclusive avenue where the prosecution at the trial level says, I will not go forward.
That's correct, Your Honor. I think we understand that to do a couple of things. One, I do think it enables the defendants to better build a record that demonstrates that their question is actually dispositive, thus taking that sort of belt and suspenders approach. I think the other is it kind of puts the state in a position of actually having to decide whether to certify these questions. I recognize that I think part of the problem in this, and this has come up in the arguments already this morning, is that right now the state doesn't really have much incentive at the trial level to not certify one of these questions. But I think when they're actually forced on the record to decide, do we want to kind of take a gamble and proceed with this prosecution, or would we rather, maybe it's not a particularly high stakes case, we'd rather just drop it and say without this one piece of evidence, it's going to be too much of a hassle, we'll drop the case. I think then you've kind of put the state in the position of making that decision more explicitly, and I think you've created a record that facilitates appellate review more cleanly.
Okay.
So I think for all of these reasons, I think we would ask this court to affirm in this case as well as in the former, and I think, may I have a moment to conclude?
Yes.
Okay. I think to the extent that the court wants to make more, comprehensive revisions to the Rule 37 procedures, we do think that rulemaking is the proper approach, but we think that in the meantime, clarifying the meaning of the scope and limits requirement and clarifying the function of the dispositive requirement in the context of suppression motions are helpful measures that are likely to result in more clarity for defendants on the ground. Thank you.
Thank you. Mr. Hayes?
Your Honors, if I may, I would like to touch just on a few points that were brought up in that argument by my friend. At the Court of Appeals level, if you will look at the brief of the state from the Attorney General's office, not one time did they argue that this was not dispositive. The entire argument was about the scope and the limits. The state and the Court of Appeals said that the question as written was too broad. But now, with the same question here today, the same state of Tennessee Attorney General's office is saying it's too narrow. So which is it? It seems like the current law of scope and limits is counterintuitive to dispositive. For dispositive, they want broad, but for scope and limits, they want narrow. So is there a middle ground? I don't know. But it can't be both. And that is the exact arguments we're trying to stop when I'm writing these briefs. The state's just changing their mind when it's convenient to them.
So why is the question as it was drafted and presented to the Court of Criminal Appeals, why was it dispositive?
Why was it dispositive? Because in a DUI case, with the court's ruling, the agreed order, which is in the technical record, the state of Tennessee, myself, and Judge Donaghy signed this. The guilty plea arose after dispositive pretrial motions. Then in number 5, the court further found that this seizure was reasonable based on an uncorroborated anonymous tip of reckless driving. The question itself goes to the heart of that corroboration, which is the seizure. If it wasn't a good stop, if it was not a good seizure, the DUI can't go forward.
Well, what about the remedial issue that the state has identified as one of the reasons why this question as drafted is not dispositive?
In which regard, Your Honor?
I understand the state's position to be that there are a couple reasons why the question is not dispositive, one of which is that it doesn't ask for a decision about if it is unreasonable, what the remedy would be, whether it would require suppression of the evidence.
Judge, that could have been written in there. I think that goes into the line of cases that I reference in the brief as far as it could be written more like a law school answer, but that doesn't mean it kills it.
Why not?
Because the understanding in criminal law, both by the defense and the prosecutors at trial level, is if that stop goes away, we can't go forward, which is why they agreed.
But that's the question, is suppression required if it was unreasonable?
Yes, my understanding of the case, this specific case, is all the parties agreed. If the court ruled that it was an unreasonable stop, it has to go away. And so that's the question is it unreasonable?
Is that reflected in the record, that agreement? Is it reflected in the record either, I take it it's not in the agreed order, but is it reflected elsewhere in the record that was the understanding?
The dispositive.
Or do you think it's just implicit in the certification?
I believe part of it's implicit, such as the United States Constitution and the Tennessee Constitution is implicit in Tennessee criminal law. Why say the Fourth Amendment specifically when we're talking about unreasonable seizures? We know what that means. We've all been to law school. It's there. It's trying to keep the question as concise as possible to meet these standards. Because our understanding when drafting this was if it got too complicated, it would get shot down because they would say it's not narrow enough. And so, and quite frankly, when we drafted this order, when we drafted the question, there was no indication from either party that this would ever be challenged as far as just on the merits. That was the understanding. We drafted it in a way just to hear it on the merits because that's what everyone wanted to happen. Now,
Mr. Hayes, let me ask you a question about what the Attorney General argued about the accuracy of the facts upon which the question was based. The unknown vehicle
Yes, sir.
instead of saying a red Chevy truck, the uncorroborated tip. What is your position on that? And
that
I
was-
may have a follow-up.
That was the heart of the motion to suppress, Your Honor. It went to it went to the totality of the circumstances. It went to JL, the Supreme Court opinion, on what counts as corroborated. JL, the Supreme Court case, says just merely IDing somebody is not adequate enough to give you reasonable suspicion. So the whole argument, the whole meat of it was the illegal activity corroborated? The reckless driving, which is reflected in the trial court's order, which says she found that the court further found that this seizure was reasonable based on an uncorroborated anonymous tip. So that is the heart of it. Did that answer your question?
Well, what does corroboration mean? When do we consider whether a tip is corroborated?
So that
or
would
not?
be, the actual merits of the case is exactly that point. When does it? Does simply getting a call saying, hey, you're gonna see this individual with a description, or this truck with a description, and to answer your previous question, the unknown, in my understanding, was the caller didn't know who he was. The caller didn't know that truck personally. It just saw a red truck and had a license plate. So unknown as far as no personal knowledge of who it was or where it was going. Not
Well, this was Polk County, right?
Polk County, that's correct. Which is important to consider. This is a very small town. Everybody knows everybody. You don't go to the Family Dollar and not see everybody you know in there. That's just the way it is in these small East Tennessee towns where we're from. Did that help answer that question?
That was an answer, yes, sir.
Okay. Any other questions from the panel?
All right, thank you, Ms.
Thank
Days.
you. Thank you, Judge.
All right. Thank you both very much for those arguments. We will go ahead and move forward with our next case. Mr. Clerk, would you call the next case, please?